Definitely. And right now we have Andrew Rodenhouse from Rodenhouse Law Group. He is a trial attorney and graduate of Hope College. Andrew received his Juris Doctorate degree from Cooley Law School. We actually got to talk to him yesterday. Andrew, I wanted to ask you, now that you've seen the whole entire first day, what are your thoughts and reaction?
Well, good morning. Thanks for having me on. I am not surprised by anything that has transpired so far. It seems to be a very standard, what we would call a trial in a homicide case. We had the foundation set with the lay witnesses appearing first, the ones who were on scene, who took the original cell phone video. We then heard from the Michigan State Police lead detective on the case, and then we also heard from the Grand Rapids police detective. Interestingly, we also heard from the evidence tech, which the evidence tech is normal, but what was abnormal was that she actually knew Mr. Schurr, knew him personally, and during cross-examination revealed how he had changed, how his personality had changed since that day, and how he was normally very kind of a happy-go-lucky kind of guy, but when she was collecting the evidence from him and taking pictures of him, that she had noticed that his demeanor had completely changed. So I found that interesting, that little bit of personal information interesting. And then we heard from Dr. Cole. Dr. Cole has been around for years and years, decades actually, in Kent County, and he's kind of a legend among the homicide trial people, those of us who try a lot of homicide cases, and we deal with him quite a bit. He's a real straight shooter. He's a real professional, and so it was interesting it's always interesting to hear from him. He didn't really provide, in my opinion, a whole lot of extra context, just simply because there's no dispute about how Patrick died, a single gunshot wound to the back of the head from close distance. The only interesting thing was how close was the pistol to the base of his skull, and he was testifying about some stippling. And stippling is the discharge out of the firearm of the gunpowder and residue that goes along with it. And if it's from more than a few feet away, the stippling doesn't appear. If you're closer than that, you'll get a stippling pattern. And what was interesting that I found was that his testimony appeared to be that he thought that the firearm was pressed up against the base of the skull. There was a little bit of dispute on cross-exam, but there's not a whole lot that he provides other than that the prosecution has to have this person come in and testify because they have to establish every element of the offense. And that includes they have to establish that it was a homicide. And that's the only person who can really testify to that, professionally speaking, is Dr. Cole. And so I think we're on track. My understanding is they've got two experts they're calling today, and we should be hearing from them first thing this morning. I don't know what order. The one is going to be a person from Axon who manufactures the taser and stun gun, and to testify to its qualifications and kind of quantify for the jury what is involved in a taser/stun gun. I think the interesting part about this, I'm anticipating the interesting thing about this testimony to be the cross-examination. And I expect that the real fight is about to begin as far as establishing whether or not Chris Schurr was or was not justified when he killed Mr. Loyola. So that's my take on it so far.
And I do want to let people who are watching this know that the expert on the taser manufacturer is testifying right now. So it'll be interesting to see what he says. But I want to go back to the crime scene tech. You had said that it was interesting to hear kind of her say that she knew Schurr and kind of knew his personality. Does that hurt or help either the prosecution or defense at this point?
I think it helped the defense because, one of the things that they have to establish is Chris Schurr's state of mind when he killed Patrick. And she's basically, by saying that, she's saying that he didn't want to. That's the demeanor, and that he if he didn't want to, but he had to, that's how justification works. He didn't want to kill this person. He had to kill this person because he feared for his own life. And so I thought that little tiny tidbit was incredibly helpful to the defense. And I found it interesting from the standpoint that it came out on cross, and that I think she had a heartfelt moment there, and I would expect that landed with the jury.
And I also want to reiterate yesterday that we saw the lawyers before this actually, or actually it might have been at the end of this, they got not into a dispute, but kind of went back and forth about entering some information that could paint a picture about Loyola. I believe it was a warrant for a domestic violence arrest. But I want to ask, when you hear them go back and forth about entering information, but then you hear that, does that contradict what they were talking about before, or is this kind of like a loophole to bring in some reality to it?
So yeah, there's specific rules of evidence that govern, and this is what and I thought it was smart for Chris Becker to raise this at that point in time and to address it, because I think the very first witness said he was a nice guy. Okay, well, you say that about your friends, right? And what the defense team was going to try to do is use that as, hey, they opened the door to this to the decedent's character. And I thought Judge Mims handled it very well also, from the standpoint that this is about what Chris Schurr knew. If he knew that the person had a violent past, then it would be relevant. But if he doesn't know about it, and he doesn't know about if he had open warrants, but I also found it very interesting from the defense team is that initially this motion had been argued outside, or had been argued in open court, but nobody covered it. There wasn't any media present. And so from the standpoint that this case is also being tried in the court of public opinion, I thought that it was a good strategic move by the defense to raise and to state what exactly they believe to be the facts regarding Patrick's background. The fact that he was on bond at the time of the offense for an OWI third out of Allegan County is what I heard them say. And I heard them say that he had was on probation for an OWI out of state, and that there was an active warrant for aggravated domestic violence, where that requires medical treatment. And normally, what I heard was that alleged victim had to go to the hospital. And so from the standpoint that the defense team was able to get some of this information out into the court of public opinion, where the people sitting at home who are wondering, what is the truth. But then again, the prosecutor, I thought, did a great job of keeping the jury protected, because it's the jury that can't hear this evidence. And so that's why, and that's, if you go back to the beginning, the judge in standard instructions told the jury, don't go on media, because you could hear things that that you shouldn't hear, and they are not being screened through the filter of the rules of evidence. And the rules of evidence are what is designed to give a fair trial, not just to the defense, but also to the people. The people have a right to a fair trial. And so from that standpoint, I thought that everybody handled it right. I thought the judge handled it properly. If she said this, if we find out that Mr. Schurr did have knowledge of this, then potentially we could revisit the issue. So if Chris Schurr took the stand and said, yeah, I saw that he had active warrants. The other interesting thing is that, and maybe it's for a different time, but police officers in general, if they're involved in an incident, they don't have the right to remain silent like a citizen does. And they're forced to make a statement or give a statement, and it's what's known as a Garrity statement. Those statements can't necessarily be used against an officer unless the officer were to take a stand and testify differently than what his Garrity statement was. They could use it for impeachment, but Chris Schurr has given a statement on this already to somebody. He would have been required to. What that statement is, I have no idea. Those are held to be confidential and privileged, and can only be used if he takes a stand and testifies differently. So it'd be interesting to know what exactly Mr. Schurr knew when he effectuated the traffic stop. He knew that there was a wrong plate on the vehicle. Undoubtedly, I mean, somebody that has an OW or somebody has a blood alcohol of over as high as he did, I forget what it was. I think it was really high, like almost a 0.3. That he would smell of alcohol. It would be obvious to a police officer making a traffic stop, and he probably was going to just go and initiate an OWI investigation. And it's possible that he knew that he had an open case out of Allegan or an open case out of state, because that would potentially be in the law enforcement information network. But then again, he didn't necessarily know who this individual was that he was dealing with either. And so all he knew was that there was a bad plate and that the driver of the vehicle. So I don't know when he was able to identify who exactly, if he knew whether this was this specific individual or if he was just conducting a traffic stop and was going to find it out later. And that's why the judge made that ruling the way she did. So I hope that clarifies it.
It definitely did.
Well, Andrew, I'm so curious to get your take on jurors being able to take part in this trial and ask questions as needed. You know, how unique is that to a trial, and how do you think that could potentially change things?
Well, so first of all, it's not unique in the state of Michigan. Michigan actually has a court rule that allows it. Michigan is unique in the country, as in we're what we would say a minority jurisdiction as it pertains to having the jurors ask questions. Not every judge allows the jury to ask questions, and Judge Mims does. And I go back and forth between whether or not I like it personally, but it's not what I like personally that matters. The judge allows it, and that's fine, I guess. But the questions that the jurors ask are still subject to the same limitations as any question a lawyer might ask. So a jury couldn't ask a question that would elicit, say, hearsay testimony, or would ask a question that would get into evidence that otherwise wouldn't be allowed if an attorney did it. And so the questions are reviewed by the judge and the attorneys. The judge calls the attorneys up to the bench. We discuss the question. Sometimes we rephrase the question, like we know what they're getting at, but we got to ask it in a certain way that conforms to the rules of evidence. And so that's how that's handled. It's unique to Michigan. It's not unique inside the state of Michigan. All the courts are allowed to do it if they choose to, and the judges have that discretion.
Interesting. I have a question for you, Andrew. We've heard 8 witnesses take the stand from yesterday, 2 of which were Leoya's friends, and then we also had 2 of the residents in nearby homes. I'm curious, and of course, obviously, we had the experts that took the stand as well. I'm curious to get your thoughts on whether you think that the prosecution has so far gotten their point across with those witnesses, or do you think they still have work to do when the defense starts to call their witnesses?
Oh, they've definitely got a lot of work to do. So yesterday was just laying the foundation for everything that's going to take place today. And I was watching a little bit on your show this morning, and yeah, there's a lot of loose ends out there that still need to be tied up. And Chris Becker is a very experienced prosecutor. He knows that. And that is going to be what he's going to attempt to do with these next witnesses. But he has to get the evidence in first, because the expert witnesses are not allowed to opine on evidence that hasn't been admitted yet. And so they have to get the evidence admitted so that the experts can opine on what they think the evidence means. And so you just got to start at the beginning. And Mr. Becker's following a very standard prosecutorial playbook. It's very formulaic. They all go to the same prosecutor schools that are where they learn to prosecute cases, and it's just a standard timeline of events. We had this thing happen. We got collected evidence. We, got body cam footage, dash cam footage, and we got all this stuff. And now the experts are allowed to come in and opine, give their formal opinion. They're the only people that can really give opinion testimony as somebody that's been qualified as an expert. So they can give their opinion as to what they think the evidence means.
And Andrew, I want to ask about winning and losing the day. I know that a lot of people who watch court cases, at the end of the day, they always wonder who won the day, who lost the day. I know it was only day 1, but is there any side that really stuck out, or is it pretty even still?
I don't, I, I know that that's a common thing for people to talk about who won the day, but it's not. Who cares? You can win all the days except for the jury verdict, and then you lost the whole trial. And so you have to win at the end, not on a daily basis. And so when I'm watching this isn't a win or lose. It's just getting the evidence in front of the jury so that later on we can argue what we think it means. And again, it's the experts and then what the lawyers are going to argue what the evidence means. And that's what the jury's going to have to do, is take the evidence that they've heard and apply it to the laws given to them by the judge.
Well, Andrew, we really appreciate you coming on again and kind of breaking down some questions that we had.